From everyday fashion to statement pieces that elevate your look, Bells has it all. Because looking good shouldn't cost
J for the state.
James Owens on behalf of Sarah Boone.
Tony Henderson, Sarah Boone.
I do.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right. Ms. Boone is seated at counsel's table, wearing a black suit and a pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to her person, so we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2 is identified in the defendant's 5th amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Most of them deal with just billings, observations by the medical personnel, so on, that don't necessarily apply to the issue of anxiety, as the court had indicated. I did include certain pages that discuss depression issues, as I believe that they were related to anxiety. And then I've identified 4 or 5 other pages that are not anxiety related that may be relevant to the case. I've described that.
Of those 119 images, how many are being sought? 15? Okay, thank you. State response.
Apparently, these are all just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures that still not in a PDF form. So of the 15 pages, the first 2 that they list are pages 9 and 10 out of 111. And I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp. So I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those 2 pages. Pages 21, and then they skip 22, 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there's a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. We are going to have at least 1 medical doctor, well 2, the forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologist will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed that's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my?
More of this initial assessment
Thank you.
of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48, and then going to 40.
What's 49? So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was
Bless you.
tested, shows that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete.
But they are also seeking 49, correct?
Yes.
Thank you.
Just 48, just like they skipped 26.
Okay.
But we don't have any particular objection. Page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018. So we don't object to that. So basically we're asking for pages 26 and 48 to be included.
Okay, thank you. The defense did, or I'm sorry, the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State 369 Southern 3rd 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records?
Judge, I did check with my secretary, Margaret, and my understanding is I didn't know that was going to be a question about when we actually sent it out. I know it was one of my trips down here. I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got them stamped at our office when something was mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late. I think it was yesterday or the day before that she was aware that they had not been disclosed. We provided the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that some of the other lawyers, one of the other lawyers had received. And we sent them on, but the problem was they had notes on them. That is a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may real quickly, based on the invoice that was sent from the our admin building department, records and stuff, but some contractor, 27th of September, I suspect they waited until they received confirmation of payment of $135 for receipt of those. So we received those. So it's all been within a couple of weeks, but we had the hurricane issue last week. And I think there were issues as to the matter of being provided for. I did speak with the state yesterday afternoon after I had a chance to look at the records, and I asked them essentially what the matter or relationship to. I was told that they already had those records and we were with them. So I don't think there was any prejudice with the state based on our submissions.
Okay. Any further argument or positions with regard to the Richardson analysis, Mr. J?
That's for the purpose of this hearing, I'd like the stack of documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
Your Honor, there was just a reference that 81 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow the court's instructions, due to the publicity in this case, I will ask for you to be removed. Does everyone understand? Thank you. You may proceed.
And I realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was
Yes,
entered
sir.
as 1, correct?
Yes, sir.
Thank
It
you.
is sub-labeled within these records as page 2 of 14. And it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that. And so I'm asking for the leeway to continue to try and search for that particular page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just at this point, I've not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119 page PDF and you make it word searchable, you just put in the magic word and it helps the attorney greatly. So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance at those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide information.
I appreciate y'all working together on that. So here's what we're going to do.
If I may.
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed, so they closed. So we were there at 8 o'clock to get the copy to the state we had promised, but we will bring one at lunch to hand to state.
Okay, appreciate it. All right. Any other argument with regard to the Richardson issue? Anything further, Mr. Beck? Okay. With regard to, let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages, 26 and 49 as, 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that are sought to be moved into evidence with regard to this January 23, 2018 incident as provided in the wonderful discovery exhibit list. Foreclose the state regarding page 68 of the 81 pages. If they were able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I've seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and, to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Judge, yeah, the defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force, the and the justifiable use of deadly force.
I'm not discussing the jury instructions at this time.
There are
YouTube, if you guys are just now hearing me for the first time, it may or may not have been my fault, and I may
Here's
or may
my
not
concern.
have said myself.
Why are we
Sorry.
addressing law in opening statement?
I agree with the state attorney. I did pull up justifiable non-deadly force.
It does not answer my question. Okay.
But it was okay.
What's your position with regard to those two, Mr. J?
Judge's opening statements, we should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case is presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to circuit recently. We may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other?
I've been doing this 35 years. I've had these boards. I've used these boards in opening statements. I don't know how many times. I've said that I would waive introducing the ones specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started. And then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions to eliminate, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory. And I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please? Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. Reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt,
Good
or
morning, Patricia.
having a conviction, it is one which is not stable, but which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Judge, I'll have it redone in arguments.
As long as we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
How embarrassing. Or he just didn't know that there was a change of law. How embarrassing.
That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening remarks. 6 through 10 are optional. We haven't decided which out of the optional instructions 6 through 10 we're going to use in this case, because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them.
Where'd it go?
And argue the law later.
Last bite at the apple, sir.
Uh-huh.
Judge, they've got to have some guidance to the law. You know, that in many ways, we do it where we give them the law at the very end, you know, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
And I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
This is concerning a murder trial for a woman that locked her boyfriend in a suitcase and left him there overnight. I can't believe they're trying to be that sneaky. It's probably Sarah's idea. Mm-hmm. And she's trying to have him thrown out. Epic fail. No. No, ma'am. Mm-mm. This judge, I want to vote for president. I know, Michelle, don't take that turn, but this guy is good. I love him. He's now my new favorite judge. I thought the judge from the Darrell Brooks case was going to be our forever favorite. He has surpassed. And we haven't even started the trial yet. Well, we're trying to, but yeah. But yeah. You sure that's even, Jamie? Yep. And he calls both sides out on their stuff, not just one or the other. If you guys want to see the visual side of this, Michelle's Criminal Musing is where we are at on the tube review. Saren, quit flirting with your lawyer. If you hear me call her Saren, that's our nickname for her. I can explain it if need be. Okay, I'll tell you since you asked. Saren, because we already have Sarahs and they're good Sarahs, and we can't call her Karen, even though she is our true crime Karen, because we have our own Karen, and she's totally not a Karen. That's how we came up with Saren. That's why you'll hear us call her Saren. And her new last name is Books, a combination of Brooks and Boone. If you have no idea what I'm talking about, it's okay. I can explain it again, or we could just move on without it. This is that blur setting powder stuff that Karen's going to yell at me for not blotting. I can't help it. I'm a dragger of the thing. That your problem might be not the concealer, it might be the shade. I use peach. 2 tones, yellow and peach. Some of us require peach. Yep. And hopefully our backup will have enough followers by then to where we could show it here too, instead of just the audio. We still need a good 140 some followers. Okay. Using the microphones, it's not me being loud at a time that we can hear. You won't be able to hear either way. I promise. I use a brush for everything else. So.
Okay. Next photo.
Oh, that's right. They're at the bench. So that's why we can't hear them. They're going through pictures that we're not to see yet. Or that we've probably seen, but the courtroom. Hi, Samantha. I see you. Aaron got you cashews from the gas station. Good morning, Renee. I think I'm still shadow banned. I have no idea what the deal is with my numbers. Daddy's coming back, Mila. I promise. I will. You're fine, Karen. Focus on doing what you need to do. If we need you, before you message us and tell us you're done, we will let you know. Don't worry, we're good. Mila, Daddy's coming back. He just went to an interview. Good morning, Allison. And Sam, you might have to unfollow me and refollow me again to see if that's why you're not getting the notifications. I may have created the event so 6 of you knew to be here and got the invite, but the others that I did it too late for, so they didn't see it because they were already in bed. They didn't get the notification. I cannot believe that they wanted to give him the records with certain pages taken out. You are good. You are good. Don't worry, Nikki. If we need Karen and Nikki, we will call for you. So focus on your work. Don't be too stressed out. We're supposed to be at the de-stress. Hi, Sue. We can't hear them because they're arguing over the physical opening statements that he wants to give with pictures on a school board project board and everything. How are you? Ow. That burnt. What they're trying to pull is that, well, technically, they're still trying to, but now they're going with a different defense, self-defense, not just battered spouse.
Any other further argument with regard to
Story,
the
what
use of
happened
those
today? Again,
items pre-marked as A through I in opening statement?
Okay.
Mr. Owens,
Mila,
when did you send
I'm
it,
gonna
sir?
tell Daddy. Don't jump into the bag of bags. It's on the door for a reason.
I have not received it.
Little kitty, little kitty. If you guys want to see the visual side of the case, Michelle's Criminal Musings on the Tube of You. That's where we're watching at. You're good with the audio? We're here. Until my backup gets enough followers, we have no visual here.
Has the state seen a copy of it?
I'm familiar with the case law. I did receive the email. I'm not sure if it indicated who all was copied on it. Separate one, I'll check.
This is just these two cases. And provided Alsager v. State,
Meanwhile,
326 7 3rd,
bags are not
656,
toys.
Florida Supreme Court 2021, Low v. State 259 7 3rd 23, Florida Supreme Court
Ma'am,
2018.
open the door.
Yes, sir.
She just closed my office door.
Judge,
I
the court
am,
has
thank
discretion to allow demonstrative aids. If you look at one or both of those, there was a state wanted to introduce a dummy they were using in a homicide
I
case.
think my hair is getting too long.
Which, the court allowed. Other cases have allowed photographs and demonstrative aids to be used in opening statements.
If everyone else jumped off a bridge, would you too?
In the Alcaguer case, which is the
Good
2021
morning,
case,
uniform.
trial court acted within its discretion in permitting state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that was in the record.
I know I was probably error messaging, but
2018
I just took myself off the internet, so we should be good.
Again, the trial court acted within its discretion in allowing a demonstrative exhibit. In that case,
We're off to
it was
light.
a murder prosecution. The trial court acted within its discretion in allowing the state to use a mannequin in a demonstrative aid in order to show the position of the gun in relation to
I
the victim's
plan
body.
to, but not today.
Mannequin
Today
was
it's
used
Sarah
to set
Boone.
out the circumstances of the crime and to attempt to establish aggravation. The mannequin was used to demonstrate the location of the gunshot wounds, the angle of the impact against the skin, the incapacitating nature of each gunshot wound.
There was no gunshots.
Advising of the trajectories were anatomical, not spatial, and had a small degree of error where only was slight difference between the victim's size and the mannequin's dimensions. There was nothing to suggest the mannequin was altered to resemble.
Glad to have you.
Court allowed, again, court's discretion. As you know, we're claiming self-defense, and part of that instruction, we're entitled to allege prior instances of difficulties and prior acts of violence so that the defendant who asserts self-defense, their state of mind is
I think I'm gonna send this court some personal little microphones so they have them to move around the court. They're behind the times, I guess. Sir, we can't hear you. And yes, the volume's at 100%. You can't see me. Can you see me now? Hold on.
They're demonstrative aids to aid the jury in understanding the
How about now?
circumstances surrounding that relationship and the actions that Sarah took and the reasonableness of those actions in light of their history.
Thank you. Any response, State?
Yes.
Yes, sir.
She zipped her boyfriend up in a suitcase and didn't let him out.
Standard is, it is your discretion, and you will only be reversed if you.
You might
abuse
need
your
to come out and
discretion
come
in this
back
regard.
in.
The state is urging you just flat out, as a matter of principle, to not
Daddy's
allow the
coming
parties to
back,
go
baby.
into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. I mean, we can do this.
You're welcome.
We can play
There's a
the
tab on my
videos.
videos. It's
We
labeled
can
Boone.
show gruesome autopsy
All my
photographs on the big
videos are in
screen
there.
as well during opening statements, but those things are all coming. So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary. Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that it's from a body-worn camera, and I think he indicated as much. It was not
Can
from her phone.
anyone not see me on TT?
If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of
Certain
the
evidence,
case
yeah,
is
catnip.
they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until
Who can see me?
self-defense has been established, and that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent, which resulted in an imminent threat of great bodily
Okay, good.
harm or
We're good
death.
then.
And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence. And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the
Mila,
problem,
Daddy's
particularly from
coming
the state
back.
side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words
Mila.
per picture. If a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, and certainly A would come in. and some of the other letters. And
Mila.
there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not, a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C,
Sure does.
D, E, F, G, H, I. State is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things. If we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C.
It was C through I inclusive?
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. It's, I don't know, it wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, Judge, absolutely at the end of the trial, great. Blow them up, use them as much as you want. But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, was pre-marked as B.
Judge, you've already ruled that these things come in. Remember that? prior
No, what I ruled is that you were able to discuss them, you address them in opening. Photographs are a totally different kitty.
I said nothing about battered spouse.
Totally different
I said
kitty.
self-defense. These exhibits come in under
I don't know why.
And arguing these. I've said nothing about battered spouse. I'm talking about self-defense.
I understand.
And prior.
Neither can I.
prior
You might
acts of
have to
violence,
reword it. Take out the
standard
YT part.
instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
In good faith, with discussions with my
It might be
client,
the YT
we believe there is going to be evidence of an overt act.
or the
She
period.
was facing imminent threat, and she reacted based on that threat.
Understood. Your response to Exhibit B?
Look at the, which one's the?
It's her on the back porch with the two dogs.
Judge, not only did he abuse, more stories abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
I believe it is a part of the exhibit list.
Mila, I promise Daddy's coming back.
This was they sent over
Honey, he
all the
is.
pictures of flowers or paintings that they want to introduce. They listed,
I'm good. How are you?
I thought for sure we put this on there, but the relevance of it is not only did he abuse Sarah Boone, what's part is he abused the dogs. And he would threaten to abuse the dogs to control Sarah Boone.
Still not working?
Okay, thank you.
Ma'am,
Good checking, Judge.
Daddy's coming back.
All right.
Here, Mama, close this.
The court's prepared to rule at this point in time. Thank you both for your presentations and your argument. The court's had the opportunity to what was pre-marked as A through I inclusive. First, with regard to the portion of the 3.9 instruction, purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You can talk about this is a job that you're going to
Good
have,
morning.
but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense.
No, ma'am.
I understand your good faith belief. I
No.
take no position on whether or not you're going to make it or not.
You
That's
already
something
did
that you're going to
there.
have to establish. But the concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be placed back into the tube, assuming that overt act hurdle is not met.
Or if you
Court,
follow the
again,
Sarah
takes no
Books
position on
hearing,
whether or not you're going to be able
when
to
you
meet it
open
because I
one
haven't
door,
heard the evidence and testimony.
cannot control it.
So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about specific some incidences may have happened, but I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements. Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense.
No, sir.
All right. Are we prepared to bring in our jury at this time?
Got some other issues.
They've been waiting for an hour and 20 minutes, Counselor.
There. Hi, guys.
We intend to play the 2-minute suitcase video to the jury in opening statement.
State.
Again, I'm asking you to urge your discretion. They're going to hear it in the next 2 days of court. It's within your discretion whether we're going to start using exhibits.
They're going to start.
What's the other issue? sir?
Defense is going to show the suitcase video from the start.
Okay.
That's great.
With regard to the video, I'm not going to allow
You say hi, Mima.
proposed exhibits to be used in opening statements. It's good for the goose is good for the gander. I'm not going to allow your photographs, not going to allow the state to do anything. You can orally talk about what you believe the evidence and testimony is
Oh, you
going to
got
show,
those too, huh?
but the actual evidence is going to have to be presented here through witnesses or through demonstration and publication after that evidence is admitted. Y'all can approach.
While we approach, can somebody?
You
from the
watch
team
this,
start
Saren.
dismantling?
Please, I would appreciate it. Thank you.
If Sam comes in, tell her Mila came up to say hi. Daddy's coming back, honey. He just had to go to an interview. He's coming back, I promise. This is who's been yelling. Daddy left for an interview, and whenever he leaves the house, she cries until he returns. I'm just trying to make her understand that he's coming back. Daddy coming back, honey. She's purring. Good morning. Okay, Mommy, we'll hold your head up. She keeps putting her head into, so it looks like my hand's wrapped around her. And it is, but it's not squeezing, don't worry. Where's your sisters? Are they being grumpy butts in their bed still? Figures. Good morning, KK. How are you? But yeah, she's been making flirty faces. I've seen her do at least 3. We need to figure out how many of the jurors are men and women. Hi.
Any reason why we cannot bring in our jury at this time? State.
No, sir.
Defense. All right, let's stand and bring in our panel.
Hopefully that loving will help to keep her from crying for Daddy. You guys are my witness, so tell him she was crying for you. I know, right? Finally the jury's being brought in. And they plan to show the suitcase clip in their opening statements. That is very ballsy. Very, very ballsy. That's like showing a signed confession right when they walk in the door.
Y'all may be seated.
Gang.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yeah.
Can the parties approach for a moment?
Catnip, I may or may not have gotten the stand to start streaming gaming on gaming nights. She's smart. Yeah, she is. And she's been doing come hither looks to her lawyers. They're not appealing. Not to me. Is that what he meant when he said, I'm not pro bono?
All right, members of our jury, good morning. I want to just confirm before we start this morning that you complied with the court's instructions last night to not have any conversations amongst yourselves or anyone else about the persons, places, things, or charge involved in this case. Then you have not conducted any independent investigation regarding those items. You just raise your hands to confer you complied with the court's instructions. All right, the record will reflect that all jurors have raised their hands. Members of the jury, yesterday I told you that you may happen to see the lawyers in the
Yeah, and if you're going to be part of that,
going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense? All right, juror in seat number 3 from my left, first row. Yes, ma'am. Okay, thank you. Can you approach for a moment? And a juror in seat 4, left to right.
You have
first
a little
row. Yes, sir. Who did you ride the
every
elevator
live
with?
telling you to quit doing your live and come play
Do you
games.
recall who specifically, sir? Mr. Owens. Okay, thank you.
Yeah, Catnip, you're going to join. Unless you unadded me. But when we do gaming, you're going to be a part of that. And someone just pulled in my driveway. I don't answer my door, though. I couldn't hear what the juror said. Not because I was over talking her, but because she doesn't have a mic. So I don't know. Sorry. What do you mean?
All right, thank you both for your honesty. I appreciate that. Something we talked about earlier this week. That's the one thing that we required and asked.
No.
To be open and honest. And I appreciate both of y'all's open and honesty.
I've got the YouTube and the
during the ride of the elevator, was there anything that you saw or observed that
I wasn't talking to you.
Influenced you in any way? Did it have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that, members of the jury, we're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. J, you may proceed, sir.
Thank you.
Really? That's odd.
Ladies and gentlemen, what the evidence in this case is going to show you that this defendant
I can't remember. Thank you, Catnip. Can you use a mic with your opening statement, sir? We'd like to hear it.
left him to take his final breaths of this event. Evidence is going to show George Torres is dead because in this defendant's judgment, sir, now with conscious disregard for whether he lived or died, we'll see.
Earlier, Karen, I've never
There's a
seen that.
suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah. The defendant will say, for everything you've done to me. Sarah, fuck you. and the defendant laughs. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't fucking breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah. 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 The defendant laughs again. Sarah, I can't breathe, babe. She laughs again. That's on you. Sarah, I can't breathe. Unintelligible words. And I would submit, is the next thing she says. Sarah, Sarah.
Because she did one.
Sarah, I can't breathe, baby. That's what I feel like when you cheat on me.
Hi, Julie. Hi,
Sarah,
Steve.
fuck you. I can't fucking breathe, Sarah. You should probably shut the fuck up. Sarah. Shh. Is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and
Hi,
lasts just
Sharon.
over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase.
Mm-hmm.
And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m.,
Hi, Texas
is
girl.
one more time, Sarah. How did we get to this point where 103-pound George Torres?
Go back to the microphone, sir. We're in opening statements, but we can't hear him when he walks away from the mic. If you guys are not familiar with this case or you haven't seen the video he was just telling them about, above my videos, there's tabs. Go to Boone. That's where you'll find it. If you want the visuals, Michelle's Criminal Musing over on YT. That's where we're at, too.
First thing she does after taking him out, I think you would hear a description like.
Good morning, Lacey.
And tries to resuscitate him. Here's her playing.
Sir, please. Mila, ma'am, no.
Share a child in common. And this day, February 24th, 2020, is a Monday.
Sir, your microphone, please.
School day, their child will share in common.
Exactly, Catnip. Exactly.
Of course, the arrangement was no co-parent. And that weekend was Friday, Saturday, Sunday. And Monday through Tuesdays, their child would be.
I think it's the court, not him. I think that's their mic system. Again.
February 23rd, 2020 was a Sunday. Now we've led into Monday. Mr. Boone has been trying to actually contact the defendant. Just wanted to confirm she was going to protect their child after school. There had been a history of reliability. You can see in the phone record, he called her, and she finally called back.
Catnip, can you check the long crime live feed of this and see if they're having mic issues as well, please?
Short drive. And
I mean, court TV. Okay. Yeah. Can you just see if their mics are working? Sometimes it's a weird thing where it works for one but not the other.
So now, after having first all their ex-husbands, they're having first waited for Brian to come over.
No, we're on law. I need you to check the court TV one, see if that has a better audio. Oh, low there. Got it. Thank you.
What you will not hear
Thank you.
are tears. You will not hear sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase, and I fell asleep. He's not awake. He's purple. He's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. She mentions that there was blood coming out of his mouth.
Sir, go back to the mic. Please. For the love of God. Sir.
Close enough.
It's them, not me. The microphone, sir.
A few hours later, the detectives from the homicide unit of Orange County Sheriff's Office approach her, are ready to interview her after doing some initial things, includes grabbing her cell phone off of the counter that was found.
If you guys are panicking, don't worry. After we're done for the day, I'll download what we're listening to here. I will enhance the audio as much as I can and put closed captions so we can see whatever the hell he's trying to say without a microphone.
In one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration.
You don't want to
expect
see
from
inside her
trained
box?
detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were just literally just enjoying one another's company. The other bottle of wine that was left over from Bohr wasn't even half full.
I didn't think
So the
about that,
description
catnip.
she is saying is 1 bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect at a restaurant.
No.
750, 750.
Microphone.
Bottles of wine that were recovered from the defendant's trash can were 1.5 liters, so the equivalent of 2 standard bottles of wine. A 1.5 liter bottle, 50 ounces. Given that a standard serving of wine is 5 ounces, you can begin to do the math. And there's receipts. The day before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are in fact Magnum.
Mila, Daddy's coming back. I'm sorry. Come
So
here. Mama will love on
that's
you.
the context that we're dealing with when we hear things like, we only had 1 bottle of wine and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class.
Is she though?
Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday.
I read your mind.
Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, in her words again, there was enough room for his little fingers to get out.
2 of them.
We were still having a good time and whatever. And basically, you know, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it. Doing art, playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. 2 little fingers could stick out. And she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're not drunk. You will be able to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drank, smoked, did art, listened to music, played with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. That's how that day ends with the police. She goes and stays at her ex-husband's house the night of February 24th. What they are doing, by they I mean more.
Back to the microphone, please, sir.
That's when they discovered the 2 videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, like, we've been good. I've been good. She describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. Hear that for years. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too.
Good morning, Parker. Happy Friday.
But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself. Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events. At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over. I flipped him over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his ears out from the zipper. No. My intention was not to leave him there. We both got in there. Both of us were there. When she went upstairs, my plan was not to, quote, he'll be up here any minute. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before. So she described it happened before. I'll never drink alcohol again. She insists that she has no injuries on her. And you don't have to take her word for it because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words.
That's what I'm forgetting.
What else is found on her phone? There's a conversation between Mr. Torres' brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Ms. Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces, nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote-unquote dad hit me in the face. Next text is, hide and seek, I shall.
Oh,
January 13th, there's another heated discussion. He describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. Brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh, Torres, referring to Mr. Torres, getting rid of.
What?
That's
She should have taken the damn plea deal or plea deal. She texted about wanting to get rid of him. He went away from the microphone so we can't hear him. That's why I'm talking. We can't hear. My volume's at 100. The plea deal would have been, what was it? Essentially, she would be getting out. Yeah, it was. Thank you, Catnip. I didn't want to say the wrong number without confirming. After I do the videos, some of this stuff leaves my head. I'm willing to place a bet, Catnip, since you brought it up first. I bet you if that's what's in the box is in the box, I bet you $50 she starts bawling the second she sees it. Or 50 hugs, whichever. I'm not on court TV, though. I'm through Law and Crime. But they can't control it. It's him that keeps leaving the microphone. He walks from the podium that has the mic, and he stands in front of the jury. No mic here. You, me, and everybody else, too. No wonder she was fighting for so many years to get all of this stuff. There was more on there than the videos. You should have taken the damn plea deal. I really wish we could have went to this trial. Did he say that her minimum was 10 in order to actually feel drunk? If you guys want to see the visual element of this, instead of struggling to hear, you can join us over on the YT, Michelle's Criminal Musings. I think I just might pick up some of those clip-on microphones and send them as a donation. I would have loved to go to this trial. But money and such. I'll look it up, Catnip. Give me a few. That's my backup, guys. I need more followers. If you guys could follow it, I would be very grateful. Then we could have the visual here too. Follow her. Please follow her. I didn't know that. If you want to go as volunteers tribute to get the inside, I will totally support that. Follow my backup. She still needs more. Thank you. As soon as we get her high enough followers, I can show the visual here too. So if you have backups and backups, feel free to send them to her too, please. It's right there. That's me. Just you put your finger on it, and then you could put the finger on the face, and then follow. It's Michelle_N_B. But you see Michelle N. It's because he keeps walking away from the microphone. My volume is at 100% on my computer. Oh, I could tap now. On the other one. My backup can tap. Anyone come in and follow my backup, please? We need her followed. You got this close to the microphone. We almost got to hear you. I didn't think about that. Good thought. I failed by not thinking of that. Guys, if you're just coming in, please scoop up my backup so we can have the visual side of court on TikTok as well as just for YouTube. Put it all together. Hi, Lacey. Follow my backup. Please follow my backup. How many is she at now? Same number. Thank you. My volume is at 100%. He keeps walking away from the microphone. So no matter what we do to hear it, with my volume being 100%, no one's able to hear it until he walks back to the microphone. Oh, it would have been. She's an idiot for not taking it. I'll look up the details in a minute, but I don't want to bog down the connection. And if you guys are on YouTube and you haven't followed my backup, I have my backup live on my TikTok. So if you guys didn't follow it, if you could go back in and follow it, I'd greatly appreciate it. Then we could have the visual there too. Welcome back. I know. I feel like we should draw a boxer on the podium and tell him he can't leave the box. Thank you,
Thank you,
PK.
Mr. J. Any opening remarks by the defense?
Judge, can we invoke the rule? It has been.
I've already advised the witnesses.
Okay, the rule of sequestration will be invoked. Thank you.
Still not
You may
enough.
proceed, sir.
The prosecutor, the defense didn't bother to go to the podium at all. We won't be able to hear anything he's saying. I believe she would have been getting 15, and with already time served, she would have gotten way less. I need to order a new chair, this one. Yes. Yeah, part of that would have been time served. It's right here.
Sarah Boone,
She's me, Michelle N.
Sarah Boone and George Torres were down and out, as you can be.
He must have gotten our message.
Their life centered around alcohol. Both of them suffered from, used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day,
Follow me.
they struggled with the use
At
of
me.
alcohol. You can imagine that. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent it can be towards it. And you're going to learn with all that was domestic violence. And that George Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years, and there were several prior incidences of violence. We've got the photographs. There were incidences where police were called. We've got
Several.
photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had. In considering her set of circumstances, that she
I was
faced
too.
with in making the decision to use reasonable force under the circumstances. And the most important thing I
Follow
can
my
tell you
backup,
here
guys.
today is keep an open mind. There's two sides to every story. You're going to hear the state's side, them attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that, all the evidence, the credibility of the witness, the photographs, the videotapes, and come to a conclusion.
We know. We will. We have. I mean, we will.
Now let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time. Here we are, October of 2024. I think the evidence is
How
going
dare
to
he.
show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix, from where they live. I believe it's Winter Park. But Publix was not too far from their apartment complex. Took their car, they drove over there. So you're going to see a videotape from Publix.
It sure
of them
is.
going in the store about noon, and they come out with one of those larger bottles of the
100%.
wine. And then, of course, there's a receipt.
If you want to see
Bottles are in the garbage can.
Michelle's criminal musings on YT, that's where we're for the live visual. But follow my backup, please.
There obviously is an attraction between the two. And as everybody knows, couples can have great times where things click, everybody gets along, and then we can have